If someone stole one thing from your business tomorrow, what would hurt the most? Your inventory? Your logo? Your client list? The process you spent years creating that only you and your employees know about? It's likely you thought of something that can be classified as intellectual property. And here's the part many business owners may miss. You almost certainly have more of it than you realize, and a significant portion of it is completely unprotected right now. And not because you did anything wrong, but because you may not have known it existed. Today we're covering the categories of intellectual property that show up in small businesses, what each one covers, and why knowing the difference matters before something goes wrong. I'm Jasmine Hurley. Welcome to Main Street Counsel. So what is intellectual property, or IP? IP is a broad term for creations of the mind that the law recognizes as protectable assets. Unlike physical property, which is always something that is tangible, IP may or may not be tangible, but it can be worth just as much, if not more, than such physical property. For many modern businesses, IP is the business, the brand, the content, the software, the influence, the knowledge, and the systems. For better context, it helps to understand the different categories of IP and how those categories may overlap depending on the particular IP asset. Copyright. Copyright protects original works of authorship in a tangible format. And this is one of, in my opinion, the most understood classifications by business owners. They assume because they haven't written a book or a song that they have no assets that are eligible for copyright protection. But that means in practice, your website copy, your blog posts, your photographs, your marketing materials, your videos, the narrative behind the software you've created, all of that is protected by copyright. Now, you don't have to file anything for copyright to attach. The protection is automatic upon creation, publication, or performance. So as soon as you hit publish on that YouTube video or you present that webinar, it's protectable under copyright law. However, that protection is limited. There are significant practical reasons to register with the U.S. Copyright Office, but we're going to cover that in a different video. Right now, the baseline protection is life of the author plus 70 years. So if you've been producing content for your business, and most owners have been, you're sitting on a portfolio of copyright protected work right now. Trademark. A trademark protects identifiers that distinguish your goods or services in the marketplace. Your business name, your logo, your tagline, your product names, and in some cases, distinctive colors, sounds, packages, and even smells. The core function of a trademark is to tell consumers the source of the goods and services. So when someone sees your trademark, the law wants that to reliably signal your business and not someone else's. Trademark protection can arise automatically through your use of trademark in commerce and extends for as long as you are continuously using that mark in commerce. But similar to copyright protection, what you own, the geographic extent of that protection, and what you can do when someone infringes depends entirely on whether and how you've registered. Now we're going to go into a deeper dive on trademarks because there are several nuances there. So make sure you subscribed and, hit the bell so you know when a new video drops. Patents. Most small business owners don't have patents, but many do, and understanding when that protection arises is critical. A patent protects inventions, a process, procedure, device, or design that is novel, useful, and non-obvious. Unlike trademark and copyright protection, you can only receive protection for a patent from the U.S. Patent and Trademark Office. Now, there are two different types of patents. A utility patent, which protects something that works or functions, a new product design, manufacturing process, or software method. Utility patents last for 20 years, whereas the design patent, which lasts 15 years, protects the ornamental design of a functional item. Patents are expensive and time-consuming. The process is measured in years, not months, and filing costs can be substantial. So, if you think you have a patent that might be worth exploring, this is a category where you definitely should not attempt to navigate without legal help. Trade secrets. Assets that are protected under copyright, trademark, and patent law are all public. On the other hand, a trade secret is confidential business information that gives you a competitive advantage provided you've taken reasonable steps to keep confidential. Your client list, your pricing formula, a recipe if you happen to have one. Trade secrets are protected under both federal and state law, but the protection only holds if you actually treat that information as a secret. If you leave your client list in a shared Google Drive with no access controls that everybody can access, it's really hard to argue that you're taking reasonable steps to protect that. Trade secrets have no registration process and no expiration date. They remain protected as long as that information remains confidential. So a practical implication is that you need to identify that confidential information and then build systems around it to protect it. This is where non-disclosure, confidentiality agreements, and access controls are really, really important for your contractors and employees. And if you've done that work, your trade secret is only protected as far as that honor system goes. Design patents and trade dress. Now, we touched on design patents, that ornamental appearance of a product, but there's a related form worth acknowledging. It's called trade dress. Trade dress covers the overall commercial image of a product or business, so the total visual appearance that consumers then associate with that source. So, like the shape of the Coca-Cola bottle, right? But trade dress can be protected under trademark law if it's distinctive and non-functional. So for product-based businesses and businesses that may have that distinctive physical or visual identity, trade dress may be underutilized. If the way your product looks is distinctive and associated with your brand, that might be protectable. Rights of publicity. The right of publicity protects against the unauthorized commercial use of your name, image, likeness, or identity. For business owners who are the face of their brand, which describes a significant number of solopreneurs and entrepreneurs, right? This is definitely worth knowing. If someone uses your name, your photograph, or your likeness to promote their products or services without your permission, the right of publicity may give you legal recourse. The law varies by state, with some states recognizing both statutory and common law rights of publicity. Some jurisdictions, like California, have stronger protections due to the prevalence of certain industries, like the film and TV industry. But the protection exists and applies to real people whose identity has commercial value. So if you're the face of your company's brand, that misuse could be devastating as much as someone misusing your trademark. So, what's the so what? As I said in the beginning of the video, IP contains several different categories of assets, and most businesses have more of it than they realize. They also may not realize their IP overlaps across categories. Your logo may be protectable as a trademark and a copyright. Think Disney. A proprietary process might qualify as both a trade secret and a patent. Well, that overlap matters because different types of protection carry different rights, different remedies, and different obligations. Properly identifying your IP assets and those overlaps will change how you approach protection of those assets. But first, you can't protect what you haven't identified. You can't enforce rights you never knew existed. So before registration, before contracts, before enforcement, the first step is the inventory. Walk through your business and ask, what have I created that has value? What information gives me that competitive edge? What identifiers do consumers associate specifically with my company? Now, to help with this, we put together an IP inventory worksheet. This will help you identify your IP assets, any protections that you may already have, and help you as you develop your IP protection strategy further. The link to grab that is down in the description. Now, that identification is step one. We're going to take deeper dives into understanding how to protect your IP and enforce your rights over the next few videos. So stay tuned. Subscribe so you don't miss it. This is Main Street Counsel. Thanks for stopping by.